Get ready for the dictation. On the count of 3, 2, 1, start. The learned single judge failed to appreciate that the entire purpose of having a unit rate system is that a bidder is allowed to quote a particular rate for all items of work related to construction, and the bidder is fully made aware about various construction activities which are needed to be undertaken by mentioning it item-wise so as to obviate any claim in future. As regards claim number 3 for cost compensation for excessive cost of embankment and subgrade construction, the arbitral tribunal awarded Rs 72,84,566 to the respondent. The tribunal found that since the site conditions at the time of execution of work had come out as more adverse than those appeared before issuance of the letter of acceptance, therefore it had become a compensation event. This finding has also been erroneously upheld by the learned single judge by relying upon in the earlier decision dated 28/2/2012 in OMP number 744 of 2010 in the case of NHAI versus Masons Somdat Builders. The single judge as well as the arbitral tribunal completely ignored the provisions of clause 305.2.2.2 of most specifications at GTS, which wrote as where specific borrow areas are not designated by the employer engineer arrangement for locating the source of supply of material for embankment and subgrade as well as compliance to environmental requirements in respect of excavation and borrow areas as stipulated from time to time by Ministry of Environment and Forests GOI, and the local bodies as applicable shall be the sole responsibility of the contractor. The single judge further did not take into account clause 305.9.1 of GTS contract agreement most specifications, which provided that the rates agreed upon and those mentioned in the BOQ was inclusive of all the operations like 1. Cost of arrangement of land as a source of supply of material of required quantity for construction unless otherwise provided in the contract, excavation in all soils from borrow pits, designated borrow areas including cleaning and grubbing and transporting the material to embankment and subgrade site with all lifts and leads unless otherwise provided for in the contract. All labor, material, tools, equipment and incidentals necessary to complete the work to the specifications. Dewatering and keeping the embankment completed, formation free of water as per clause 311. The reading of above clause coupled with clause 1.2, which provided for site information, clearly established that the work of constructing the embankment and subgrade construction was included in the unit rate method, and no claim for excessive or additional cost ought to have been entertained later on. As regards claim number 5 for compensation for idling of resources, the AT held that the appellant NHAI failed to hand over possession of obstruction-free construction site on time, thereby causing delay and idling of resources. The learned single judge as well as the arbitral tribunal failed to take notice that as per clause 110 of technical specifications, the respondent contractor was responsible for removal of hindrances, and this was also a paid item. Therefore, the respondent cannot be allowed to raise a plea that the site had to be handed over encumbrance-free. The respondent had to make a bid after making due inspection of the site, which makes it clear that the respondent was fully aware of the nature of impediment and hindrances existing on the construction site. The single judge, as also the arbitral tribunal, failed to appreciate that the respondent had to prove actual losses suffered by it, adducing necessary documentary and other evidences, which it completely failed to do. The arbitral tribunal fell in error by awarding notional overhead cost in a big organization dealing with a number of projects by applying internationally accepted formula for overhead costs, which was not the actual costs losses suffered by the respondent. Single judge failed to appreciate that the said method was completely erroneous.